Well, hello everyone, and welcome again to this live session, live employment law session. My name is Lior Samfiru. I'm the employment lawyer. That's what they call me. And I'm here live with you and for you to answer your questions, to solve your pressing issues when it comes to employment law. That's why I'm here. I'm here live to make sure that you know what your legal rights are. So let's break this down again. My name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. My firm, we operate across Ontario, across British Columbia, and Alberta. So if you're in one of those provinces in Canada, we've got you. We can help you. And right now, I can answer the questions that you have about your legal rights. Very easy to do. Ask your question. Type it in. Hit enter. I'll read it, I'll see it, and then you can walk away getting my answer to your specific situation. This is live. I'm here to talk. I have a lot of stuff to talk about, but I'd rather take your questions and talk about the things that you want to talk about. So be the second voice on this session. Make sure your questions are answered. Whether you have a question about a wrongful dismissal, a lot of people are being let go right now, more than usual. Maybe it's a situation where your boss is relocating you, sending you to another location. Your business is sold, maybe. Maybe you're being mistreated or bullied by your boss, by a coworker. What to do, what to say. I think you get the idea. You can ask the question right now, and I'll be able to answer it and give you that guidance. Remember, we have excellent employment laws across this country, really good employment laws. Unfortunately, not too many people know what those laws are. Too many people don't know what the law can do for them. Well, I do, and I can tell you, and I can make sure that you're not being taken advantage of. That's the whole point of having employment laws, is that no one can take advantage of you. Now, before we get started for the day, of course, let me start off by giving you some additional contact information. If you want to connect with me and my team off social media, off this live stream, very easy to do. You just go to employmentlawyer.ca. Right there, employmentlawyer.ca. You can get phone numbers are there, email addresses are there. You can fill out a form if you prefer. It's all there for you. It's your one-stop shop for anything and everything employment law. So again, employmentlawyer.ca. I'll refer to that more throughout the session today. But that's for after. Right now, I am live with you here, making sure that your questions are answered. Questions are already coming in. So please take the fact that, use the fact that we have some time. You don't need to be rushed. Last week it happened. Right as I was saying goodbye, I got a couple more questions. I didn't get to answer those. Don't let that happen to you, of course. Get those questions answered. My name, of course, is Lior Samfiru, the employment lawyer, live here. Let's start answering some questions. Our first question today, Bill. Thanks for asking, Bill. And Bill is on Facebook, and he says, I've been out of business for 14 years, and the company is not paying me, or are you saying I've been at the business for 14 years? The company is not paying me the proper vacation pay amount after the 10th year, percentage-wise. What should I do, even if I have brought up the topic to my management and human resources and ownership several times? So there's two options here, and they're both going to work very quickly. First option is you can file a complaint with the government, with employment standards. They'll deal with your employer, and they'll have to pay you, including retroactively. All right, they'll deal with that. They'll order your employer to pay. So that's one way to get this issue resolved quickly. The way to resolve this even faster than that tomorrow is to have me send your company a letter saying you better pay up or else, and see how quickly they get their butt in gear and they pay you what they need to pay you. Obviously, the company has to pay the proper amount for vacation pay. It's not up to them. It's not discretionary. We have laws for that reason. So, Bill, employment standards or a letter from me. Problem with employment standards, they're overworked. By the time they get to it, it could be months potentially. Whereas we can get that resolved very quickly. If you want my help and my team's help, Bill, easy to do. Go to employmentlawyer.ca. You see that address on the screen. Again, employmentlawyer.ca. Phone numbers there, email addresses there. It's all there to reach out and connect with me. All right, great question to start off with. Thank you for that, Bill. See how easy it is for those joining us. I'm Lior Samfiru, the employment lawyer, and I'm here answering your questions live. I'm going to continue answering questions, but ask yours. Please don't hesitate. Don't be bashful. Don't worry about anything other than getting answers to your questions. All right, Justine has our next question. I've had a modified work schedule for the past 3 years due to stress and anxiety. Now, a new manager is asking to change this drastically. They've ignored several doctor's notes. What can I do here? Well, they can't do that. If you have a doctor's note says that you need modified duties or modified work schedule, your employer has to do that. It's not up to them. They can't deny it. They can't say we don't believe your doctor. They can't say we want a second opinion. They have to do what the doctor told them. And by the way, we know that that they're able to do that because you said they've been doing that for the past 3 years. So it's a no-brainer. If your employer refuses, it's a human rights violation. That could be a constructive dismissal. It's completely illegal. As I was telling Bill, the easiest way to resolve this, get me involved. Once they get a letter from me, see how quickly all of a sudden they accommodate you. They'll be, oh, it's just a big misunderstanding. Our bad. Of course we're going to give modified hours. So, Justine, that's the way to do it. Connect with me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. Make sure, of course, you have that doctor's note. If you have that doctor's note, they have to follow it. Otherwise, you call me and we'll deal with it. Thanks, Justine. Very good question. Question that comes up very often, so I appreciate you asking. I think there's a lot of people that may want to know that answer as well. All right, let's see. Bren has our next question. What happens if your employer removes accommodations you have had in place for a few years? Great question. It's exactly what I was talking about with Justine. If you need accommodation, your employer has to provide that accommodation. Now, remember, it's not enough for you to say, I need this. Your doctor has to say that. So if you have a doctor that says you need 1, 2, and 3, you will need these accommodations, your employer has to do it. And they can't say that it's too hard because they've been doing it already. So clearly it's possible. So if you have that doctor's note and they won't help you or they won't do it, you call me and I'll deal with it. If you haven't given them the doctor's note, you were just trying to tell them yourself that you need that, get that doctor's note, okay? It's that doctor's note that they have to follow. They don't have to follow what you say or what you think. They have to do what your doctor says. Have your doctor be very specific. If they don't follow your doctor, Bren, you call me. We get this resolved very quickly, okay? To connect with me, of course, Bren, Justine, all of you, employmentlawyer.ca. Again, employmentlawyer.ca, the way to do so. Looking forward to connecting with you. Don't be bashful. Let's have that discussion as soon as possible. All right, great questions. Lots of questions coming in. Keep them coming. Please, please keep them coming. I'm going to continue answering right now. My name again is Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Want to answer your questions live. All right, let's continue. Let's see. Next question from Aline. I was on a 1-year contract through an agency prior to being hired full-time with the company. Would this year be considered as part of my severance? Absolutely. So in a situation when it comes to your severance, obviously, the more seniority you have with the company, the better the severance, the more severance you get. So if you started on a 1-year contract and then became a regular indefinite full-time employee, all your years count, including that first year when you were quote unquote on contract. That counts as well. So if you're on a contract for a year and then you became a regular employee and you were let go 5 years later, well, you're now a 6-year employee, not a 5-year employee. That means you're going to be getting full severance based on those 6 years. And of course, the more years, the better. But here's the thing, Aline. Doesn't matter what you're offered. Even if you think it's a good offer, there's a 90% plus chance that what you've been offered is not even close to being enough. 90% of people, over 90%, when they're let go, whatever they're offered, even if they think it's actually good, it's not even close to being good. It's not even close to being what the law says you should have. So if you're let go, doesn't matter if you work for a year, for 6 months, for 37 years, doesn't matter. You call me and you call me right away and you do not sign that severance offer, okay? Of course, to connect with me and my team, easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. All right, continuing to answer questions. See how easy it is? Ask your question right now. Take the time to write it in so I can see it and read it and answer it. Bill has a follow-up question on Facebook. Bill was asking about vacation pay, and I told him how to resolve the vacation pay issue. So Bill has a question. What if they fire me after I take these actions? It's completely illegal to fire you because you're trying to get your vacation pay. We call that reprisal. An employer is not allowed to fire you, to punish you, to mistreat you because you're pursuing your legal rights. It's illegal. There's significant legal consequences for doing that. So I can't physically stop your employer from letting you go. But man, if they do, I can definitely make sure that they pay the consequences. I wouldn't worry about that. Okay, they would have to be pretty crazy to do that, because again, it's going to cost them a heck of a lot more than they ever imagined. It's illegal to punish an employee. This is important for everyone to know. It's illegal to punish an employee for standing up for your rights, for pursuing your rights, for demanding your rights. So if you're owed overtime or vacation pay, or you think that the company hasn't paid you your wages properly and you're demanding that, you're acting to pursue that, you cannot be punished in any way for doing that. And you have the full protection of the law in that case. So Bill, hopefully that makes sense. Let me know if it doesn't. Thank you for that follow-up question. Guys, you see how easy it is. Bill had a couple of questions, including a follow-up question. He got answers. You can as well. Don't be bashful. Let's make sure you get those answers right now. All right, let's see. Liz comes up to us with our next question. I have made some headway and need to ask you about the likelihood that an employer will take an issue of constructive dismissal to court, or would they more likely settle? Well, I don't know anything about your case, so I can't say, Liz, what your employer will or will not do. Best thing I can do is tell you, don't even try to think about dealing with this yourself, okay? Let's connect with me and my team at the office. Here's the thing. 1% of cases make it to court. Probably even less than that. So the chances, just statistically, of you having to go to court are tiny. But of course, I can't say more without knowing about your matter. Most cases resolve very quickly, and most cases resolve without being within 1,000 feet of a courtroom. Okay, so I wouldn't worry about going to court. But again, to be specific, I would need to know everything about your matter. Best advice right now, Liz, as I said, call myself, my team at the office. Let's have a proper consultation. To do that, employmentlawyer.ca. Again, employmentlawyer.ca. Now, we've talked already about severance a few times here, and I've already told you that in most cases, whatever severance you've been offered is 90% chance to be inadequate. Well, how do you know for sure? How do you find out right now, if you want, how much severance you should be getting? Or how do you find out right now if what the company offered you is fair? It's so easy to do. You grab your smartphone, you grab your tablet, anything that has internet, and you go to pocketemploymentlawyer.ca. It's right there on the screen, pocketemploymentlawyer.ca. We created a tool called the Severance Calculator. You can find that when you go to pocketemploymentlawyer.ca. What does the Severance Calculator do? Well, it's all in the name. It calculates your severance. It calculates the amount that you are owed. It takes seconds to use that, literally seconds. You answer a few questions, and it tells you if you're owed 6 months, 18 months, 24 months of severance. It's right there for you. By the way, it's completely free. Completely free. It's completely anonymous. No names, no phone numbers, no email addresses. It's there just for you to use. There's no strings attached to it. And if you want, and only if you want, when you get your severance result, there's a green button you can press, only if you want, to connect with me so I can help you get that severance. You don't have to do that, but you can do it. So if you lost your job, you go to pocketemploymentlawyer.ca. If you're worried about losing your job, you go there. If you're just curious and you're wondering, hey, I wonder how much severance I would be owed if something happened, pocketemploymentlawyer.ca. Our severance calculator has been used by over 2 million people across Canada. Check it out yourself. All right, but that's later. Again, right now, I'm still here live with you, for you, answering your questions about employment law. So what do? You ask the question. You're still here. I'm still here. Let's make sure that you get answers. All right. Richard has our next question. Our plant is closing, and I've been told I might be moved to a new spot. This location is much further away. Is there any way to get severance instead, or would this be considered a resignation? I was a supervisor and have been employed for over 20 years. So here's the thing. If your relocation is going to mean that you're driving now more than an hour extra than you did before, so it's going to take you an extra hour to get to or from work than it did before, then that's a constructive dismissal. An employer that is going to relocate you that far away is not allowed to do that. That means that if your employer is going to implement that relocation, you have two options. You can accept the relocation, of course, and continue working at the new location, or you can consider that relocation a termination, a constructive dismissal, and then you have to get your full severance. Now, for Richard here, after 20 years, he could be looking at as much as 2 years worth of severance. But again, if the new location, let's say, is 20 minutes away, probably not going to be enough. An hour usually is kind of what I look at. So if that means because of the relocation, now you're spending an hour more to get to work than you did at the previous location, constructive dismissal territory at that point. You don't have to accept it. And it's not a resignation if you don't accept it. It's a termination. You have to get severance. So that's kind of the bar there, Richard. Before you do anything, okay, this is very important. Before you say yes or no to the company, before you say constructive dismissal, before you say anything, you call me. We have to do this right. You don't just go off and do whatever you want to, because if you do, you may actually make mistakes. We have to do this right. After 20 years, there's a lot at stake here for you. So again, we're going to do this right. You connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Okay, let's see. Patrick has our next question. And by the way, guys, we still have close to 15 minutes, 14 minutes or so on this session. So lots of time, right? Lots of time to ask questions for me, Lior Samfiru, the employment lawyer here, answering your questions live. So don't just listen. I know I'm a lot of fun to listen to. Ask your question, all right? By asking questions, you'll be helping not just yourself, but others that may have similar questions to you. You'll be helping them as well. So Patrick has our next question. Patrick joins us from YouTube. My company is closing their doors, and I'm on long-term disability. My insurance company has told me that they have no job to retain me to go back to and want to kick me off. My employer refused for the last 6 weeks while they've been open to do a return to work plan, and now I'm being told that we aren't even going to get severance. So let's just kind of unpack this. First of all, if you lose your job, you have to get severance, full stop. Okay, there's no option to let you go without severance. And in fact, if you're on long-term disability, you may get even more severance than if you were not on long-term disability, because it's going to be harder for you to find another job because you're not well, right? You're not yet able to work. So it's going to be harder and take you longer to find another job. So of course, they have to pay you even more severance. But here's the thing. Right now, the company may not have a job for you today. Let's assume that. But you're not ready to come back to work now. And you may not be able to come back to work for a month, for 6 months, for a year. How would they know today that they're not going to have a job for you in the future? So it actually may be illegal to terminate you today on the basis that there's no job because you're not ready to come back to work today. So the company has to only assess that at the time you're ready to come back to work. So just the fact that they're letting you go in and of itself could be illegal. But of course, you're owed severance. Keep in mind, of course, that whether or not the company lets you go does not impact your long-term disability benefits. You can stay on long-term disability until you're able to go back to work, or until you're age 65, whichever happens first. So you don't lose on that. But Patrick, this is definitely something that we need to talk about off live stream, off air. So I want you to connect with me as soon as possible. Okay, don't wait on this. Let's connect through employmentlawyer.ca. Again, employmentlawyer.ca, and I'll make sure to help you. And I want to find out a bit more about your situation, because everything you've described, Patrick, is completely and totally illegal. Okay, so Patrick, employmentlawyer.ca to connect with me. All right, that was a fantastic question, and certainly something that comes up often. Now you know if you ever are faced with that situation, but maybe that's not your situation right now. Maybe you have a different situation. Ask the question. Let's make sure you still have about 10 minutes or so, plenty of time to ask a question and get me to answer it. I'm going to continue answering questions right now. Candice 199 asks, how do you get a supervisor or manager to take harassment complaints seriously? I've voiced complaints several times, and now they've been ignored or belittled. This has gotten worse after returning from leave. So first of all, anytime you file a harassment complaint, you have to put it in writing, always. You can talk to someone, you can talk to HR, but you always follow up in writing. Email works great, saying, here's the issue, please deal with it. I'm asking you to deal with it. Legally, they're required to. It's not something that they have a choice. There's no option here. By law, they have to take it seriously. They have to do an investigation, whether it's them investigating or bringing an outside investigator. And ultimately, they have to do whatever needs to be done to fix the problem, to rectify that situation. If they don't, if they still take it lightly, despite you putting it in writing, that's a violation of several statutes. It's illegal. It can also be a human rights issue. It can be a constructive dismissal. If you've tried in writing and they've ignored you, you call me, okay? You'll have several options. I can give them a kick in the pants and they'll deal with it, or I can get you out of there and get you a bunch of compensation. It's going to be up to you. The key, of course, is to put it in writing. You don't want the company to say, oh, no, you've never told us. We never knew. They can't say that if you put it in writing, all right? So that's what you do, Candace. You put it in writing, and if they don't resolve it, you contact me right away. To contact me and my team across Canada, employmentlawyer.ca. Again, employmentlawyer.ca. Guys, for the last few minutes of the session, if you've just joined us, my name is Lior Samfiru, the employment lawyer. As you've been seeing, I'm answering employment law questions across Canada. If you have an issue, an employment issue about your job, your compensation, your boss, your rights, ask it. Don't be bashful. You still have time to get those answers. I'm going to continue answering questions right now. Okay, Patrick has a question. My employer refused for the last 6 weeks that they've been open to do a return to work. Okay, so Patrick, sorry, I've answered that question already about your employer that won't bring you back to work when you're on a disability. So Patrick, you need to connect with me. Chrissy has our next question. Chrissy, let's see. If you're let go during a big company restructure and it's for financial reasons, does this impact the amount of severance they owe you? So no, the reason you're let go does not impact your severance. What could impact your severance is if you're let go in an industry that's struggling. So for example, if you're in an industry that doesn't have a lot of jobs because people are just being let go in that industry, then it's going to be harder for you to find another job. That means even more severance. But the company's own reasons don't impact your severance, whether they're doing well, they're doing bad, if it's restructuring or not. No. The main factors that go into assessing severance, Christy, are your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. So as I said, Christy, before, if you want to find out now, today, how much severance you're owed, easy. You just grab your smartphone, you go to pocketemploymentlawyer.ca, again, pocketemploymentlawyer.ca, use our severance calculator tool, and you'll find out in seconds how much you're owed. But no, the company's reasons don't affect it. But here's what I've said before, and I want to say it to you. Without knowing anything about you or your company, I can almost guarantee you that whatever they're going to offer you is not going to be enough. That's true for over 90% of people. So whatever they're offering you, whatever you think of it, it's not likely going to be enough. So do not sign that severance offer. As soon as you have that piece of paper, you call myself, call my team. We'll have a chat. We'll go over everything, and we'll help you get the severance that you're owed. So, Christy, hopefully that helps you understand what your rights are. If you are in that situation, employmentlawyer.ca is the place to go. All right. Let's see. Continuing to answer questions. Grace. I was originally scheduled to return from mat leave next year, but have to extend the time as I'm struggling to find daycare. My boss has informed me that this is not acceptable and I must be at work by my original date. Do I have to abide by this? No. You can be off for up to 18 months. So you have what's called a right to a job protected leave for up to 18 months. So if you want to extend it more than 18 months, you need the company's permission. But if it's up to 18 months, let's say initially you said, I'm only going to be off for 12 months. And now you want to extend it to 16, to 17, to 18 months. You can. The company doesn't have the ability to say no. The company doesn't have the ability to oppose it. They can't do anything to you. Of course, you want to let the company know as soon as possible and in writing to avoid any questions, but it's not up to the company to approve. They have to allow that time. If they don't, man, there's going to be significant repercussions. Okay, great. So now you know that answer. But again, in writing, tell them you're extending it, but again, only up to a maximum of 18 months. Okay, let's see. Continuing with questions or answering questions. Patrick, I've tried to call your team, and they told me I have to get things in writing before you would talk to me. So it's not that you have to get in writing before we would talk to you, is that there's probably nothing that we can do until the company says that they don't have a job for you. If you hear third hand that they're going to let you go, that's not letting you go, right? If the company lets you go, then we can easily get involved right away. But if they haven't let you go, which means they haven't told you, they haven't given you something that says they're letting you go, there's nothing yet to be done. If it's something the insurance company said to you, that ultimately doesn't mean anything. So if you're not sure, why don't you send an email to the company saying, I've heard this from the insurance company. Is this true? If they say it's true, then there you go. We're good to go. If they say it's not true, well, then at this point, nothing has happened. So that's why it's important to get things in writing, because otherwise it becomes a he said, she said. So practically speaking, unless you've been let go, or you're told you don't have a job, or that the company won't bring you back from a disability leave, there's nothing yet that we can do. But you can, if you send that email, you can kind of speed things along very quickly. All right, let's see. This may be our last question today. Sammy, is it possible to negotiate your severance with your employer before getting a lawyer involved? And I get asked this often. So you're asking me, is it possible? The answer is, yeah, sure, it is possible. The real question is not whether it's possible. The real question is it likely to succeed? And in my experience, it's very unlikely to succeed. And let me tell you why. Number one, when you ask your employer for more severance, what motivation do they have to get you more severance? First of all, your employer may not even realize they owe you more severance. What we want your employer to do is to speak with their lawyer so they can be told what I've been telling you, that you're owed more. They're not going to speak with their lawyer just because you contact them. They'll speak to their lawyer because I contact them. As soon as I contact them, first thing they'll do is contact their lawyer. Their lawyer is going to tell them, yeah, you owe more. We negotiate, we resolve it, and you move on. So the chances of you being able to resolve the issue on your own, very small. But it can even be worse than that. If you're not a lawyer, you may not even appreciate how much you're owed or why you're owed that. So you may ask for the wrong things in an inappropriate amount, and you can hurt your own negotiating position. So I've had many matters over the years where someone tried to negotiate on their own. They failed, but they actually made their position worse. They made my life and my job a lot more difficult because they did something to compromise that position and made it harder for me to get them the severance that they're owed. So ultimately, the only time I would recommend negotiating on your own or say that it's okay is if you have a really strong relationship with the person at the company that's making the decision. If you're close friends, you have a very strong relationship, then you can use that relationship to your advantage. But unless you have that type of a relationship, I don't recommend it. It usually doesn't work. And oftentimes you can actually hurt yourself by doing that. So my best advice is if you lost your job, let's talk about it. Connect with me and my team through employmentlawyer.ca. Guys, I think I have time for one last question, and this one is going to be from Tyler. My daughter recently started a part-time job, and her employer is holding back tips until she completes probation. Is this legal? It's not legal. Your employer cannot hold back tips. It's a breach of the Employment Standards Act. You can go to the Ministry of Labor for that. You can contact me and I can send them a letter. It's not legal at all. I see another question just came in. Let me take that from Jack. Does December account for potential additional severance due to the holidays and companies typically not hiring during this time of year? Yes, absolutely. So if you're let go in December, it's probably going to take you more time to find a job than, let's say, if you're let go in January or February. So that means even more severance that you would be getting otherwise. More reason to contact me and my team if you're let go, because we need to account for that to make sure that you get everything that you are owed. Again, to connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. Guys, this is the time I have for today. Thank you so much for joining me. And great questions today. Some fantastic questions. Hopefully I've answered all of them. But again, I'm going to shut down my computer here, not my computer, my camera, and get back to work. but I'm not going anywhere, okay? You can reach me and my team now, today, if you want. Just go to employmentlawyer.ca. Phone numbers are there. Email addresses are there. We can connect there very, very quickly. Thank you, everyone. I'll be back next week. Don't wait, though, until then, all right? Let's talk before then. Thank you so much for your time today, and we'll talk again soon. Take care.